Hi, I'm Denice Gierach of the Gierach Law Firm. We in our law firm represent many businesses just like you, handling all of their legal needs for the business. For many years, we have been acting like firefighters for many of our clients, putting out fires that the businesses themselves have found themselves immersed in because they signed documents that were never reviewed by legal counsel. And in fact, were probably never read thoroughly by the client's business team. Why did this happen? Well, the business team wanted to buy a service or a product, and the vendor came in with their own contract. The contract may have been as little as 2 or 3 pages, or may have contained a lot of fine print. The business team may have only looked at things like the price or when things were due versus looking at the entire contract. So in effect, they only focused on certain things rather than the whole picture of what is in the contract. So lest you think that this doesn't apply to you, I have some real-life examples of things that I've seen in my practice. Many you could probably relate to. For instance, many businesses require that their employees wear uniforms. Well, your business is not going to wash those uniforms for your employees, and the employees are not going to wash and iron and keep everything pressed and looking nice for themselves. So the business team looks for a company that will provide the uniforms, launder and return them back to the business. And then the vendor comes in with their own contract. It is a fairly short contract, and the business team for the company just signs the agreement. Turns out that the deal is for 5 years, and the contract for the first 4 years, the service is okay, but then over time it diminishes. So when it gets towards the end, your business team is like, when is this going to be over so I can find another company to take over for this? But then they read it and they find that it has an automatic renewal provision in there for another 5 years if you don't give notice within or before 6 months of the end of the contract. Oh no, now you have a contract for another 5 years with a company that wasn't any good to start with. So another example is, have you or your team ever used a non-disclosure agreement, commonly known as an NDA? These are usually shorter agreements, and most of the business team thinks that they're all standard agreements anyway, so they routinely sign them without really reading the terms thoroughly. So let's say you're setting up a strategic alliance with another company. And as part of that process, both companies want to look at each other's trade secret documents and other paperwork. However, the NDA provides that each company is agreeing to keep the trade secret information secret only for 2 years. Is that really what you had in mind when you had your business team sign this? Speaking of strategic partnerships with other companies, your business team signs an NDA. Your company provides documents to the other side, and the deal never goes through. Did you identify in the NDA that the trade secret documents had to be marked confidential in order for them to be treated as such? If your business team did not do that, are they required to be kept confidential by the other side? When the other company returns these documents to your business team, Are these documents even considered trade secrets anymore, since your team did not identify them as such? Another example is your business team enters into an agreement with another company that company has a restrictive covenant, such as a non-compete agreement or provision in the language of the contract that is broad enough to keep your company out of a particular market. Well, no one goes into an agreement thinking that it won't work, but if that happens and it does not work, are you prepared to fight with the other company over the terms of that broad non-compete that your business team didn't notice? Let's say your business team wants to build out some proprietary inventory management software that will leapfrog you ahead of your competition, as most of the software that's immediately available out there to your competitors for inventory management is inadequate. The vendor makes all sorts of promises, all verbal, and of course requests the money up front. The vendor is a Canadian company. The business team signs the document without legal counsel, giving it a short look, and starts the process. Both the process and the software are a complete disaster. It does not work in the manner that the verbal promises made by the vendor said it would. It's created chaos in your accounting system, and it's caused that accounting system to crash. Worse yet, you're in the middle of an audit and you need those inventory numbers. Can you get your money back and start over with a better vendor? As in the previous example, where the vendor is a Canadian company, the agreement also said that you have to sue the vendor in the event of any disagreements in the province of Canada in which they are located. So, that's called a venue provision in the agreement. So you have to hire a Canadian attorney to sue this vendor to get your money back. Well, what's the law in Canada that will allow you to do this? These are but a few examples of agreements that were either not read at all or that were read only cursorily and not generally understood. How do you change that and protect your company from that risk? One way is to change your mindset from hiring an attorney and thinking of the attorney's fees as a cost rather than an investment in your business. You may think that this is a self-serving suggestion on my part, but think of this. An attorney is going to make more money from your company putting out the fires that are created from not using that attorney up front. Next, consider developing your own template documents that are commonly used and template language that you can incorporate into all of your contracts. This too is an investment for your company in having an attorney actually do this for you. The third thing you can think of doing is training your business team on how to handle vendor contracts. They need to know when to hire lawyers and when they are okay to look at these documents themselves so that they don't end up in this problem. The fourth thing is hire your own in-house counsel so that they can handle the contract issues and look at everything. Many of our clients hire us as an outside general counsel. As part of our service, we do a risk analysis over all areas of the business, and for contracts, we will review all signed and open contracts, looking for those potential ticking time bombs that may exist. And then we inform you of the potential issues we want your business to be focused on, growing your business and not putting out fires. So if you'd like to learn more about this topic or how to use an outside general counsel, feel free to contact us at the phone number or the email that's listed below. Thanks for listening, and I'll look forward to seeing you the next time.